Hello again. Welcome to this series of podcasts about the difficult and sensitive issue of domestic and family violence. Thanks to Donna Cooper for her use of materials and PowerPoint slides. In this first podcast, I will discuss with you some of the social context and recent inquiries and evidence about family violence, and provide and discuss some of the research on types of violent behaviour. First though, we begin with examining some of the sources of best practice in domestic and family violence matters. On 27 July 2016, the Queensland Law Society released its Domestic and Family Violence Best Practice Guidelines. Those guidelines are available on the Blackboard learning page for this module. They do not, of course, operate as legal principles, but they represent the most up-to-date approach. In this course, we are going to do our best to incorporate relevant parts of those guidelines into your learning. There are a few key principles drawn from the Queensland Law Society Best Practice Guidelines that can help the way we discuss family and domestic violence. First, domestic violence can affect anyone, regardless of age, gender or wealth, where they live or their cultural background. Second, when discussing issues of family and domestic violence, listen and respond respectfully and sensitively. Third, develop and maintain your own knowledge of the social context in domestic and family violence, including power, control and gender. Fourth, make sure you know and keep yourself updated on the law so you can give considered and careful advice. Fifth, and finally, consider cultural, religious and gender issues which may have an influence on a client's reluctance to disclose and discuss family and domestic violence. You should take a look at those materials on Blackboard. There are other resources available to assist in developing best practice in this area. The Family Court of Australia's Family Violence Best Practice Principles, issued December 2015, is available from the Blackboard page. This document provides a practical framework for representing clients in litigation, but also discusses some legal principles, including the principle of unacceptable risk of family violence, which we will return to later. On the link also, on the slide also, is a link to the Family Law Council or Family Law Section Best Practice Guidelines for Lawyers Doing Family Law Work. This was released in 2010, but now, as of July 2016 at least, is under some review. I should pause at this point just to examine some issues of terminology. There are some specific legislative terms that we will look at shortly. In particular, the concept of domestic violence in state legislation and the definition of family violence in the Family Law Act. You will see the term domestic and family violence. That term is not specifically from legislation per se, but is really an umbrella term covering the whole of the area. So now it's time to consider some of the recent reports and evidence about the social context of domestic and family violence. We begin with a report by the Domestic Violence Task Force, chaired by Dame Quinton Bryce, delivered to the Queensland Government in 2015. The report is called Not Now, Not Ever, Putting an End to Domestic and Family Violence in Queensland. The report is very long. The first volume runs to 368 pages. That volume is available via the Blackboard page in this module. I do recommend though that you limit your reading, at least for this course, to the executive summary and the recommendations. The task force reported that in 2013-2014 there were 66,016 occurrences of domestic and family violence reported to Queensland Police. This equates to over 180 incidents of domestic and family violence being reported every day across Queensland. 17 homicides relating to domestic and family violence occurred in Queensland in 2012-2013. On average, across Australia, one woman is killed by her partner every week. The annual cost of domestic and family violence to the Queensland economy is, according to this report, estimated to be between $2.7 billion and $3.2 billion. The report also sets out that the picture in Aboriginal and Torres Strait Islander communities is even bleaker. The task force was said to be deeply distressed by what it heard about violence in these vulnerable communities. It was reported that violence and abuse is so prevalent in these communities so that they have become, that is, these conducts and behaviour have become normalised, so the people who can live there consider violence to be a part of their everyday life. There were 140 recommendations from the report. Some of those recommendations were that the Queensland Government work with universities to identify suitable ways to incorporate into professional undergraduate courses education and training on how to identify when domestic and family violence is occurring and how to appropriately intervene. A specialist domestic violence court be established to deal with all related domestic and family violence and associated criminal or breach of domestic violence order proceedings. This process is currently being trialled in the Southport Magistrates Court, and that the Queensland Government introduce a circumstance of aggravation of domestic and family violence to be applied to all criminal offences. Turning back to the issue of the Family Law Act, in October 2015, the Australian Institute of Family Studies delivered a report entitled Evaluation of the 2012 Family Violence Amendments. It too is a lengthy report. It is available on Blackboard, but is there only for your additional information and extra reading, should you wish to take a look at it. In that document, the Australian Institute of Family Studies reported that in one of the studies examined by them, some 60% of separated parents reported a history of emotional abuse and or physical violence before or during separation, and that this continued for a slightly lower proportion after separation, with a longer term insight suggesting that problematic dynamics continue for some 25% of separated parents for periods of up to 5 years after their separation. One of the key messages, I guess, for us as family law practitioners and potential family law practitioners was that those parents who do use family law systems tend to be those affected by complex issues, including family violence, mental ill health, substance abuse, and safety concerns for themselves or their children. There is an article included in the QUT readings material for this module called Differentiation Amongst Types of Intimate Partner Violence, Research Update and Implications for Interventions by Joan Kelly and Michael Johnson. This was published in 2008. As set out on your slide, these authors identify 4 different types of family violence typologies. Of those, perhaps separated instigated violence and violent resistance, that is, to other violent conduct, are perhaps the most recognisable. You may not be familiar with the term coercive controlling violence. This is defined as a pattern of emotionally abusive intimidation, coercion and control, coupled with physical violence against partners. Situational coupled violence, as defined by these authors, is used to identify the type of partner violence that does not have its basis in the dynamics of power or control, or power and control, more correctly. At pages 493 to 494 of that article, the authors discuss the implications for family law disputes. They suggest that, in effect, occurrence of coercive controlling violence is more dangerous for children than other types. The categories used by these authors are not universally accepted. For the purposes of this course, though, it is important to recognise that the term domestic and family violence covers a whole range of conduct, but also that the context and frequency of the behaviours may be relevant to determining the level of risk to a child or children in the making of parenting orders. Before moving to the content of the legislation itself, I wanted to briefly deal with the interaction between the legislation. There are two acts that we are going to look at in some detail. The Domestic and Family Violence Protection Act, Queensland, 2012, and provisions of Part 7 of the Family Law Act 1975, in the Commonwealth. For the purposes of this course, it is sufficient to be aware that the Family Law Act is fundamentally a civil jurisdiction, which means that police do not have power, as a general proposition, to enforce orders made by a court under the Family Law Act. In this course we do not cover, in any detail, the civil penalty provisions in the Family Law Act for breach of parenting orders and injunctions, nor do we cover contempt of court in parenting cases. Be aware though that under the Family Law Act a court does have certain powers to punish those in breach of a parenting order. The only occasion in which police will intervene to enforce a parenting order, generally speaking, is when specifically authorised by a court by way of recovery order, or in very limited circumstances in which a court has power to issue a warrant of arrest. Otherwise though, as I mentioned, police have no powers and there is no criminal offence, in the sense of being in the criminal code, of breach of a parenting order. This is one of many reasons why it is particularly important to have specific state legislation for the protection of individuals. There are specific criminal penalties in the Domestic and Family Violence Protection Act, and police have extensive powers to arrest and detain offenders, and in certain circumstances applied to a court for orders irrespective of the intention of the parties concerned. Alright, that's it for this short introductory podcast. Thanks for listening. Next, I'll take you through the state legislative framework and examine some relevant cases.